breach of confidence is an equitable remedy that enforces a duty of good faith on those who obtain information in a relationship of trust. However, there are circumstances in which a defence may be available whereby courts will refuse to protect information on the basis that to do so would be contrary to other public interest. Breach of confidence actions, on one hand, serve the public interest by encouraging trust and good faith. However, they may also inhibit the public interest by preventing the disclosure of matters of serious public concern. The public interest defence considers how these competing interests can be balanced. However, it is not simply the case that a recognised public interest will automatically trump the obligation to preserve private confidences. It is likely the public interest defence would only apply to matters of legitimate concern, and although this is not being defined precisely, this could include information about public threats, crime or corruption, exposing lies or deception, or even serious maladministration of government or powerful private agencies. The practical use of a potential public interest defence can be demonstrated in the 2014 case of Barry Spur and New Matilda. Barry Spur, a Sydney University professor, had private emails containing racist comments published without his permission and argued they were in fact never intended for widespread publication. On the other side, the publisher, New Matilda, contended that there was a public interest in knowing Professor Spur's sentiments, given he was part of a team of specialists involved in the Australian Curriculum Review, in which he recommended that the English curriculum focus less on teaching Aboriginal and Torres Strait Islander literature. Although this case was never decided due to an out-of-court settlement, Australian courts have indicated that in such situations a narrow approach to the public interest defence would be taken, confined to the exposure of an inequity in the sense of a crime, civil wrong, or serious misdeed or public importance. On the other hand, a broad approach may be taken in the case of government documents or information. In these cases, the onus would be on the government to prove that it's in the public interest for them to remain a secret. This reflects the general ideology that it is in the public interest to be able to debate, review, and even criticise government action, and that whistleblowers are essential to a proper democratic system. However, the key is to differentiate between whistleblowing involving genuine disclosure of illegal, immoral, or illegitimate practices to the leaking of information motivated by other reasons such as personal disagreements or simply to embarrass. What about celebrities and tabloids? In Woodward and Hutchins, Lord Denning found that as pop stars had created favourable but false images of their private lives, there was a public interest in the truth being told. However, Australian courts have somewhat retreated from these broad comments and suggested that a public interest must be more weighty and precise than a broad public interest in the truth being told. In other words, there is a difference between the concept of public interest and what the public may be interested in. The fact that the story as a whole might be in the public interest does not provide an excuse to throw in confidential details that are merely juicy.